Luca asked me to talk about Japanese university invention rights. But I am not a Japanese lawyer. I am a registered foreign lawyer. So I'm giving my personal knowledge, but please consult a Japanese attorney with regard to the specifics of Japanese law. I think
Ron, can I ask you one thing?
Yeah.
Can you also maybe explain, because maybe not everyone is familiar, but maybe they heard about the definition of patent agent and attorney that is very typical of the US, but still might be kind of interesting to know.
Sure. So first of all, I am a US patent attorney, and our firm serves clients all over the world. We have clients in Europe, in Japan, and in the United States. In Japan, a patent attorney is not necessarily qualified to practice law in any other area. Okay, so a bengoshi is allowed to practice in any area of law, international or national, within this country. There are offices here. There are 4 exceptions to that, carve-outs. As a gaiben, as a foreign registered lawyer, I'm allowed to practice law for my own country, or not any non-Japanese law if I get an opinion from someone who is qualified in their own jurisdiction. A Zeirishi does tax law, the Yoshisoshi does legal scrivener, kind of specialty items, and a Benrishi can practice intellectual property law. Okay, so that's what he was referring to. In particular, before we get into the weeds, very specifics, who here has ever invented something that was the subject of a patent search? Raise your hand. Okay. So I take it, no, has anybody here submitted a disclosure of an invention to a patent attorney? Has anybody ever heard of that? Of writing down your invention so a patent searcher or a patent attorney could search to see if it's patentable? Okay, all right.
I have a wish to do it.
Okay, all right. So, okay. So, one of the very important issues in determining who owns an invention, and this is across the board in every jurisdiction, is who the inventor is. Who is the inventor? And that has to do with conception. It has to do with determining who conceived and made what is patentable in the claimed invention. A lot of big, sort of maybe foreign words, but the invention isn't just your idea, or at least the patented invention isn't just your idea. It's an intersection of several pieces. So you might have a great idea and it has various little embodiments. For example, I could say that a support structure is a general idea, but a particular embodiment is a chair, or a bench, or a lab table. Those are all particular. So maybe one of those embodiments of your idea will be new and inventive. And that would be what your patent attorney will determine and draft after making research into what's been done before. Does that make sense? Okay. So in Japanese universities, the owner of the invention is the person who's going to get the money, right? If you own it, then you have the right to file. You have the right to prosecute and obtain it. You have the right to sell it. So ownership is a bundle of rights, just like with a house, right? So if you have real estate, it's a bundle of rights. So when it comes to an invention, you have two choices. Those rights can be protected by way of secrecy, with a trade secret, or by way of patent protection, where you disclose the invention in various jurisdictions, one or more, and in exchange, the government gives you a right to exclude others from practicing it for a limited amount of time. That's what a patent is. So the public policy idea is, if you disclose your idea according to certain requirements, it has to be clear, it has to be complete, it has to be sufficient to allow others to practice it after the term of the patent ends, then the government will give you the ability to file a lawsuit and stop others from practicing your invention. So at the outset, you need to figure out whether you want to keep it secret, if you can, because a lot of inventions can just be reverse engineered. But if it can't be reverse engineered, trade secret protections are great. So let's pretend that it can be, like a chemical that can just be put into a chemical analysis machine. Oh, we know what that is. So we make it. You file a patent. So if you're an inventor and you are a student or a non-employee at the Japanese university, technically, you're considered theoretically to be the owner. However, the realities give a lot of power, and the practicalities mean that it's going to be owned by your university. For example, if you use machinery from your laboratory, the university is considered to be the owner. Or if your research is funded by a specialized large project government research grant, not just some run-of-the-mill type of grant that most researchers get to be students. In addition to these legal considerations, as a practical matter, your supervisor as a vested employee, in other words, that supervisor has more in common with the research university than he does with you, will have power to influence you to assign or sell that invention if the university wants it. Okay, so similar to what Lucas said, if the university finds that it could be patentable, then they will basically ask you to assign it to them. And if you don't, well, bad things could happen. And just generally, I think there's a sense of loyalty that students have to their universities for allowing them to be there and use their resources and knowledge. So you can see that although the law technically says that non-employees, students own their inventions, if it's valuable, it ends up going to the university. If you're a professor or other employed inventor, let's say you're a postdoc and you're employed, then again, the university will probably own it and be able to exploit it through a pre-existing employment agreement or a policy. So under Japanese law, I believe that a university is treated in the same way that any other employer is treated under the Japanese patent statute. You can also, the university will also get potentially partial rights through way of a non-exclusive license if it's performed within the scope of your duties as an employee. Up until last year, there was a theoretical problem in the law that would keep a university theoretically from claiming the priority date, and I can get into that later, if for some reason the employee sold his or her rights to file the application before selling it to the university. Okay, and that was corrected as of last April 2006. That was corrected, and a very unique area that is shared in Korean law and German law that gives fair compensation. It might also be in Italian and in French, I don't know. But yeah, so if you are an employee, you cannot just have all of your rights taken away. just by signing them away when you're employed if the invention is extremely valuable. So, for example, in the United States, at employment, you would assign your rights, and no matter how valuable the invention is, it's over. You get nothing more other than continued employment. And there's no requirement for the amount of compensation to be fairly measured against the value of your invention. Whereas in Japan and in, I think, I know Germany and Korea, I think under most civil law countries, correct me if I'm wrong, there's this idea where there's a fair distribution that would mean more monetary payment, such as in Italy, you get 50% of the money, which is excellent. I think it's very nice for the inventors. However, I think Kei Danren was a little bit upset by the Nietzsche case where the blue LED, blue diode inventor was able to get, I believe, about $8 million additional compensation. I think I mean in yen, I don't know the figure, but equal to about that. And I think it was the Supreme Court knocked it down, or they settled it. The Supreme Court said, you know, you better settle. I think he got $2 to $4 million. I think the Japanese large companies didn't like that risk, and so they lobbied the Diet, and now fair compensation was watered down, unfortunately for inventors, not simply to include money, but also stock options, promotions, a pay raise, paid leave, opportunities for studying abroad, which sort of takes some of the teeth out of the provision. So I hope that sort of answers some questions about how the rights are generally distributed in a Japanese university. Otherwise, you know, do we have time to just go through the patenting process?
Ivan, yeah, just as you want.
Okay.
Ivan is ready.
Okay. Well, if you want more information about university rights in Japan, there's an excellent article that I can send you. It's in English. It's written by a professor in Japan, and it will explain much better than I can all the ins and outs. Please just email me. You can reach us at harrisfirm.net, and I'll be happy to send you any related information about this topic or any other IP topic. So, thanks a lot.
Thank you.